So Oklahoma realtors don't have to use buyer agreements anymore. Let's slow down a little bit and unpack this because the issue is not quite as simple as what people are making it out to be. There are always more layers to this, and there is more nuance and more detail. And so stay with me till the end because we're going to cover 4 things that I think are important that you need to know. Those 4 things are this. We're going to cover the Oklahoma Real Estate Commission. We're going to cover the MLS. We're going to cover the settlement, and we're going to cover getting paid. And so if you want to talk about getting paid, you got to stick around to the end to hang out with me so you know exactly what's up. But here's the deal. Oklahoma passed some legislation that is trying to conflict with the NAR settlement so that buyer agreements may not be required before showing properties. Now, look, I have my opinions on this. I'm going to tell you in this video who can actually definitively give you an answer as to whether this is doing what it's intending to do or not. But I just want you to have all of the information and the details and the nuance so that you can make the best decision for your business. Do not take everything at face value or as simple because it isn't. There's a lot for us to talk about, okay? Let's start at the beginning. What happened? We'll go to the very, very beginning. And back in 2019, NAR got sued. Fast forward, there were settlements. And as a part of those settlements, and now we've settled from both the seller perspective and the buyer perspective. And those settlements said there had to be certain practice changes. Now, here's what functionally happened. NAR settled and they said, look, all of our members that were members at this date, you're covered under the settlement. And that means if you follow the settlement agreement, then you're covered, which means your clients can't come and sue you for antitrust until this thing expires 7 years down the line, prospectively. But as long as you're following the rules of the settlement agreement and the practice changes, you're covered, you specifically, your brokerage, your company, you individually, okay? But these practice changes had to go somewhere else. They were incorporated into the MLS rules. And so the MLSs were a big part of this because they settled separately under the agreement. They opted in and they said, hey, look, as an MLS that opts in, we will make different rule changes that incorporate these practice changes, like getting buyer agreements before showings. Now, there was an exception within the settlement that was built in that is key to what we're going to talk about today. And that exception said, if these practice changes are inconsistent with federal or state law, then you don't have to follow them. That's the crux of this. Inconsistent. Let's get into it. So we know right now we have MLS rules in place and an NAR settlement that says, look, you got to get buyer agreements before showing properties. Here's what happened. This year, the Oklahoma legislature passed Senate Bill 1217, and it's very short. It's very simple. Here's what it says. It says that a broker shall not be required to enter into a brokerage agreement prior to showing real estate. Okay, that's step 1. Broker shall not be required to enter into a buyer agreement before showing property. But then it goes on to section B here, which actually throws a little bit of a wrench in some of this perhaps, that says a managing broker can choose to require the associates underneath them, their branch office brokers, their associates, to enter into buyer agreements before showing. So here's what simplified, this is what it says. It says, hey, look, brokers, you shall not be required to enter into broker agreements before showing properties, but you have the choice. You can voluntarily choose to have people within your brokerage enter into buyer agreements before showing properties. Now, a key point here is that this was already voluntary under state law. Don't forget, this was an NAR settlement. This was a private class action settlement. This wasn't a matter of state law. There was no law on the books in place that said you had to enter into buyer agreements. It's an MLS rule that flows by virtue of that NAR settlement that happened. So state law already in Oklahoma said you don't have to have a written buyer agreement. It didn't exist. There was no obligation to do it. So state law coming around now saying, well, you don't have to do it, you shall not be required. Well, we're just mirroring what state law already said. But the purpose of this, the intent behind this, is to create an inconsistency with the NAR settlement. Let's look at it, because what the NAR settlement said, and here's what one of the rules is. I pulled the MLS OK rules for the sort of Oklahoma City area and many other areas in the state, one of our larger MLSs. This is their rules, and this is exactly what came from the NAR settlement. And it said, unless inconsistent with state or federal law. We see that right at the beginning. When you're working with a buyer, you're required to enter into a buyer agreement before touring a home, and it has to have 4 things in it. 1, specific disclosure of specific compensation or the rate of compensation. The amount of compensation that is objectively ascertainable and not open-ended. A term that prohibits you from getting paid more than what is in the buyer agreement, and a conspicuous statement that the broker fees and commissions are not set by law and are fully negotiable. It's this part of the beginning that we're really focusing on here, and it's this word inconsistent. Unless inconsistent with state or federal law, you have to do this. So what was proposed was this legislation over here that tried to create an inconsistency right here. A broker shall not be required to enter into a brokerage agreement with a buyer prior to showing real estate. But then we just don't forget this. We created this secondary piece that says, but you can choose to if you want to. So this is the crux of the issue. Is this language right here taken as in its entirety, this thing that says you don't have to do it, but you can choose to do it if you want to and require it as a broker, is that inconsistent? Does that create state law that is inconsistent? Now, what that means is we have to figure out what the word inconsistent means, because if our state law is in fact inconsistent with the NAR settlement, then that is correct. You are not required to enter into buyer agreements then before showing properties. But if it is not inconsistent, then the rule still stands. So we have to figure out what inconsistent means. Well, I went and I pulled some legal definition from Black's Law Dictionary. Now, look, I'm not saying this is the definition that would be relied on, but I think that we can look at it and try to figure out if we think this is inconsistent or not, because you're going to have to make this choice as you decide what you're going to do in your business. So here's some definition language from inconsistent. Mutually repugnant or contradictory. Contrary, the one to the other so that both cannot stand. Or in this case, the acceptance or establishment of the one implies the abrogation or abandonment of the other. Now, that's some language right there. But let's think about what this means. Mutually repugnant or contradictory. Contradictory, that like these two things are opposite of each other, that they, or in this case, that the one to the other so that both cannot stand. What that means is that I can only follow one, I can't follow both. In this case, the acceptance of one implies the abandonment of the other. The way I read this is it's a true conflict, that for it to be inconsistent, state law has to basically say you can't do this. You follow me? It doesn't say that like, oh, well, you have choice. That's not inconsistent. Choice is not inconsistent, in my opinion. It doesn't create a true conflict, where a conflict, that inconsistency means I can either follow the NAR settlement requirements or I can follow state law. I can't follow both. If I follow this one, I have a problem over here. And if I follow this one, I have a problem over here. In that case, that's inconsistent. That is a true conflict. But where state law says you have the choice to do this thing, is that really inconsistent? I think you have to figure that out, and you have to figure out who actually has the decision of whether they can tell you it's inconsistent or not. Because sure, I can sit here and tell you, in my opinion, I don't think that creates a legal inconsistency. That when state law gives you the choice to enter into written buyer agreements, in my mind, that means, well, if I want to have the protections of the settlement and I have the choice to follow it, then I have to do that if I want those protections. Okay. And that just means you got to decide what's best for you. But let's talk about what really matters here. There's 4 things I want us to cover. OREC. So the Oklahoma Real Estate Commission has a law that says now that brokers, you shall not be required to enter into buyer agreements, but you can choose to require that if you want. That's great. But what is OREC's role with regards to the settlement agreement or the MLS rules or you getting paid? This is going to sound kind of harsh, but let me be clear about this. Irrelevant. And that's not that the real estate commission is irrelevant, but what I'm saying is they don't factor into whether you have to follow the settlement or not. They don't factor into whether you have to follow the MLS rules or not, because they don't have jurisdiction over these things. The real estate commission cannot tell you that this state law is inconsistent with the settlement. They do not have jurisdiction over that. That's not their position. They don't have that say. They're not the one person who can actually tell you whether our state law is in fact inconsistent with the settlement and the MLS rules. Okay, that's just not their position. And so, great, from the real estate commission's perspective, whether you follow the settlement or not, whether you follow the MLS rules or not, is fine as far as they're concerned. They're not going to fine you if you don't have a written agreement because it's never been state law. That's not been their thing. So really, as far as the real estate commission's concerned, they just don't factor into this. That's not to say they're irrelevant from what we do. Obviously they are. They're important. But that from this perspective of what we're talking about, they just don't really have a say in it, so to speak, right? It's just not their position to say whether this state law is consistent with the settlement or not, right? That's just it's not what they do, okay? Okay, so then let's talk about the MLS rules, because there are two separate issues here, the MLS and the settlement. What I mean by that is, if you want to follow the MLS rules, they get to say what their MLS rules are. And that is separate from if you want to be covered under the settlement agreement. What that means is following the MLS rules are like, I chose to join this MLS and they get to tell me what the rules are to be a participant. And as far as the settlement is concerned is, do I, as an agent or a broker, want to be covered under the settlement? So let's come back to the MLS and let's stop over here at the settlement first, okay? Because one of the questions you have to answer if you're the broker, because state law gives you choice. So I'm talking to the brokers in the room for a minute, is if you want to be covered under the NAR settlement and be immune from liability from getting sued for these kinds of claims, do you need to follow the settlement or not? Well, in general, the answer is going to be yes. And here's my problem that I have with state law is that to rely on the settlement and state law saying you have a conflict, then you would have to say that, like, I'm okay with not following the settlement terms here because I believe that it is inconsistent under state law to do so. But who gets to tell you that, right? Who actually has the jurisdiction to weigh in and say the settlement is, in fact, inconsistent with our state law now? And as far as I can tell, there's one person. It's not me. It's not me. It's a judge. Because we've got a settlement agreement here, and that question of is it inconsistent or not, it's not for me to say. It's not really for the MLS to say. It's not for the real estate commission to say. It's a judge. That's really the only person that can truly weigh in and say, yeah, I think that your state law is inconsistent. I mean, maybe the Oklahoma Attorney General could do an AG's opinion. I actually don't even know that it's eligible for that. I'm not sure that they could weigh in on a private settlement because that's what it is. So the only person who can really declare it with any sort of like definitive answer is a judge. Because if you roll the dice and you end up getting sued over it, then that's who's going to make that decision, right? Getting sued, you can't say, well, look, our real estate commission, there's a rule over here and it's fine with them. Well, that doesn't matter. And the MLS says this. Well, I mean, does it matter? It doesn't. The only question is, are you covered under the settlement agreement? And the only surefire way to be covered under the settlement agreement is to follow the terms of the settlement agreement, right? Until a judge comes in and says that we're inconsistent. And that means you got to make a choice. If you decide that you think it's inconsistent and you're willing to waive that protection under the settlement agreement, then do whatever you want. You don't have to get buyer agreements signed before showings. It's totally fine. That's going to be up to you to decide. But the question is, if you do want to be covered, the only surefire way to maintain your protection under the settlement agreement is to follow the buyer agreement requirement. Otherwise, you just got to determine, are you willing to accept the risk that I'm not covered under the settlement agreement? And does that matter? Is the risk low? Yeah, it probably is. Is it zero? It's never zero. Just depends on your situation and whether you're okay with waiving your protections under the settlement agreement. Because when you stop following the settlement agreement, you waive your protections under it. Now, the MLS is a factor because the MLS rules, as we looked at, they still have a requirement that says I have to have a buyer agreement before I actually show properties. And so while we have a state law that purports to be inconsistent, is it actually? And we don't know what the MLSs around the state are going to do. And so right now, as of today, this is a question mark. The MLSs have not issued any sort of opinion that says, yes, we think state law is inconsistent with our rules that we looked at that say you have to have a buyer agreement. So part of this is right now, maybe let's wait and see what the MLSs come up with and determine, are you willing to potentially be in violation of the MLS rules? Because I could absolutely see a case where the MLSs come in and say, hey, we don't think this is actually inconsistent. And in order to protect themselves and maintain their protection under the settlement agreement, they might very well say, we think the MLS rule still stands because the MLS rule gives you choice. And by choosing to come join our MLS, that means you need to follow our rules, which require a buyer agreement before showing. Follow me on that? I hope that tracks because I think that there's different factors here. And again, I know this sounds harsh saying irrelevant, but again, the Real Estate Commission just doesn't govern this or this, and this doesn't necessarily govern this. These are all three independent things that all vary. So this is where you have to then wait and see what happens here. This whole thing doesn't even go into effect until November 1st, so it's not even today. The settlement, I don't know, maybe, maybe not. We may never know. And as far as the Real Estate Commission is concerned, you get to do whatever you choose to do, right? That's how that works. But let's talk about getting paid, because I think this is important to understand. Are we now at a place where we're just back at the old way of doing business? Are we back at procuring cause? Are we back at I never have to do buyer agreements? And the answer to that is no. Procuring cause is still not a thing. And we are not back under the old offers of compensation in the MLS. That ain't coming back. This factors one thing. And the only thing that this impacts is timing. Because you still have a rule under the MLS rules and the settlement that say you're capped at what's in your buyer agreement. And that means if you want to get paid, you still need a buyer agreement. That requirement hasn't gone away. The only thing that's potentially changed is the timing of it, right? Because remember, state law over here says not required to get a brokerage agreement with the buyer before showing real estate. But as we looked at, our MLS rules still have terms like this. You still have to have a written agreement that has your compensation and that it's open, it's not open-ended and it's ascertainable. And you can't get compensated more than what's in your buyer agreement. So as far as being a rule follower goes, which if you're following this long, you probably are to some degree, this state law doesn't change the existence of a requirement for a buyer agreement. The only thing that it actually changes is the timing of it, right? So that means you got options. That means you got to figure out what you're going to do and when you're going to do it and what that looks like in your business. And look, we did a full 50-minute game plan in our Pro Access community where we broke down sort of the 4-step game plan and the 4-step choices that you might have. If you want access to that, then head on over to see in the comments here a link to see what Access is and how you can join. But at the end of the day, let's just remember this isn't in effect until November 1st. We've got a law in the books that will go into effect then. And there's a real question as to, does that truly create an inconsistency with the MLS rules and the settlement? And what are the MLSs going to say? And even if the MLS weighs in and says their opinion, does that really impact your coverage under the settlement agreement? And do you even care about your coverage under the settlement agreement? I'm not here to tell you what to do or what the right answer is. I'm just here to hopefully share some insight into why this is more complicated, more nuanced, and there's some more details that are being missed by a lot of people that are talking about this. And so I hope this helps fill in some of the full story so that as this progresses, you know what to look for and you can make a decision that works best for your business.